Illegal workplace behavior almost never looks like a movie. There is no villain monologue. It looks like a time card that got edited after you left, a quick favor that adds up to an hour you were never paid for, a write-up that appears the week after you complain. We don't discuss pay here. That calm is the disguise. Most managers who cross a legal line are not screaming, they are smiling. They use the language of professionalism to cover behavior the law might treat very differently than your handbook does. The real skill here is the relabeling. Unpaid work becomes commitment. Retaliation becomes performance management. Discrimination becomes drama. Safety neglect becomes business reality. Pay secrecy becomes professionalism. The system does not only rely on bad managers, it relies on good employees being embarrassed to defend themselves. Here is the uncomfortable part. Not every bad boss is breaking the law. Plenty of managers are just incompetent, cheap, or unpleasant, and none of that is illegal. But some bosses are counting on one thing. They are counting on you not knowing where toxic management ends and legal trouble begins. The less you know about that line, the more confidently they step over it. The first way is the one almost nobody reports, because the theft is designed to look too small to fight. They make you work for free. Not all at once, they do it in pieces. Be logged in before the clock starts. Finish the closing checklist after you clock out. Answer the message at 9 at night because ignoring your manager feels like career suicide. You do most of it without arguing because saying no over 10 minutes makes you feel like the difficult one. Under the Federal Fair Labor Standards Act, covered non-exempt employees generally have to be paid for the hours they actually work, and generally must receive overtime at not less than 1.5 times their regular rate after 40 hours in a work week. If your employer knew or should have known the work was happening, the fact that the overtime was not approved does not automatically turn that work into a gift. It wasn't authorized is a budgeting problem for the company. It is not a free pass to keep your labor. So when a manager tells you to clock out and then finish the task, or trims your recorded hours, or treats logging all your time as you being inefficient, that is not a culture of hard work. That is how wage theft survives. It is built from 1,000 tiny unpaid favors that each feel too small to fight, taken from everyone, every day, and dressed up as commitment. Some bosses do not reach into your wallet. They shave minutes off the clock and call it loyalty. The second way begins the moment the workplace realizes you are no longer silent. Retaliation. It means an employer punishing you because you asserted a protected right. Reporting discrimination, reporting harassment, raising a wage complaint, flagging a safety problem, cooperating with an investigation. In many cases, the act of raising the concern is protected, even before the company admits the concern was valid. Here is how it usually looks. Before you complained, you were reliable. You were great with the team. Then you reported something, and almost overnight you became difficult, negative, and somehow not a team player. Suddenly your manager wants everything in writing. Suddenly old mistakes become new evidence. Suddenly the meetings happen without you. A write-up appears for something 3 other people do every day without consequence. The write-up is not always about performance. Sometimes it is the receipt for speaking up. Now the honest part. Not every bad thing that happens after you complain is retaliation. People do get disciplined for real reasons, and timing alone does not win a case. When a spotless record collapses right after you complain, the timing is not a coincidence you should ignore. It is one of the first things investigators look at. Most people never raise it anyway, because they are afraid that naming the retaliation is what finally makes it worse. The third way hides behind one of corporate America's favorite laundering words: drama. Let me be precise here. A rude manager is not automatically breaking the law. Being a jerk is legal in most of the country, but harassment or discrimination tied to a protected characteristic is a different category. Federal law generally protects against discrimination based on things like race, color, religion, sex, national origin, disability, genetic information, and, for workers 40 and older, age. When mistreatment is connected to one of those, you are no longer talking about a bad personality. You may be talking about a legal problem. Watch the translation work management does to keep it small. He was just joking. That's just his personality. You're being too sensitive. We don't want to ruin his career over this. Harassment becomes banter. Bias becomes miscommunication. Discrimination becomes culture fit. The company does not always deny what happened. Sometimes it renames the conduct until it sounds harmless. Every one of those sentences does the same job. It converts a possible legal issue into a personality conflict, and once the company frames it that way, it becomes easier to delay, to minimize, and to protect the person causing the damage. When HR calls discrimination a personality conflict, ask who benefits from that translation. It is almost never the person being harmed. You tend to accept the label anyway, because by the time HR is done talking, you are the one who feels dramatic for having named it. When a company knows about harassment or discrimination and protects the useful offender instead of dealing with the conduct, it has not stayed neutral. It decided the comfort of one valuable employee was worth more than the rights of the one getting hurt. The fourth way is the one people associate with construction sites, and that association is exactly why it gets missed everywhere else. Workplace safety. Under federal law, employers are generally required to keep workplaces free from serious, recognized hazards and follow applicable safety standards. It is the warehouse with a forklift nobody maintains, the clinic with no real plan for a violent patient, the store so understaffed that exits get blocked, equipment gets rushed, and people get pushed into unsafe shortcuts. The job with chemicals, no protective equipment, and a manager whose entire safety plan is, "You'll be fine." These workplaces rarely say, "Risk your body for profit." They say it gently. "Just be careful. We don't have the budget for that right now. Are you sure you want to file a report? It's a lot of paperwork." That last one matters more than it sounds. Pressuring people not to report injuries or punishing them for raising safety concerns can itself become a serious legal issue, separate from the original hazard. A company that treats safety like an inconvenience is gambling with workers' bodies. When the bet goes bad, it is not the company that pays with a back, a hand, or a lung. The danger keeps running because everyone around you has already agreed to treat it as normal. The fifth way is the one most workers have no idea is even a right. They try to stop you from talking to your coworkers about pay and working conditions. Here is what a lot of employers hope you never learn. Under the National Labor Relations Act, many private sector employees have the right to discuss wages, benefits, and working conditions with their coworkers, with or without a union. Talking about your pay, comparing schedules, raising a group complaint about workload or unsafe conditions. That kind of collective conversation is often protected activity. So when a manager says, "We don't discuss pay here," look closer. Often it is not professionalism at all. It is information control. "We don't discuss pay here" is how a company keeps you from finding out that the person doing your exact job makes more than you do. Companies love transparency when it means employees are visible to management. They become allergic to transparency the second employees start comparing notes with each other. When a boss tells workers not to discuss pay, they are not always protecting professionalism. Sometimes they are protecting the pay gap. Most workers go along with it because they were trained to treat salary secrecy as a sign of maturity. This does not cover everyone identically. Supervisors, many public sector employees, and some independent contractors sit in different categories with different protections. But for a huge share of ordinary workers, that conversation you were told to avoid is closer to a right than a rule. So what do you actually do with any of this? Start by documenting. Keep your own record of dates, times, what was said, and who was there. Save messages, schedules, pay records, performance reviews, time cards, and policy documents where you are legally allowed to keep them. Memory fades and gets argued with. A record does not. Be careful about recording conversations. Some states let you record a conversation you are part of, and some require everyone to consent. Know your state's law before you hit record, because getting that wrong can hurt you more than it helps. HR is not your lawyer. HR exists to protect the company, and that sometimes overlaps with protecting you, but never confuse the two. For anything serious, the real options live outside the building. The Department of Labor's Wage and Hour Division handles many federal wage issues, and state labor agencies may matter too. The EEOC handles discrimination, harassment, and retaliation tied to EEO protected rights. OSHA handles safety. The NLRB handles protected concerted activity, including pay discussion. An employment attorney can tell you what your specific facts actually mean, because not every bad boss is breaking the law, but some of them are counting on you not knowing the difference. They're counting on your fear, your confusion, and your politeness to keep the machine running, and that ignorance is part of the business model.